A federal court just dropped a bombshell ruling that is a huge win for parents in the Encinitas School District in protecting their children from gender ideology and indoctrination in public schools. This is a really important case, and I'm going to dive into the details and tell you what we can expect next. Hey, everybody, I'm Julie Barrett, and I'm the founder of Conservative Ladies of America. And I'm excited to be talking to you today about a huge win for parents and children's rights out of the state of California. Parents Tom and Rebecca Doe have a fifth grade son at La Costa Heights Elementary, where he was participating in a mandatory buddy program where the fifth grade students mentor a kindergarten student. And the students were together, the fifth graders and the kindergartens were together to do an activity. The students were read the book My Shadow is Pink by a teacher, and then they were to do an activity with their buddy where the kindergarten student would draw their shadow and color it in the color that they feel best represents their gender identity. Now, this book, My Shadow is Pink, was written by a man for his child who preferred typical girly things. And so he thought he would write this book about it's okay for boys to like to wear dresses. And in the book, the boy is frustrated because he goes out and wears a dress. And apparently that doesn't go over very well with his peers. And his father tries to console him by putting on a dress. The father's in a beard and comes into the boy's room to console him and let him know that it's okay for boys to wear dresses and boys to like pink. Now, I think it's perfectly acceptable for children to like any types of toys or any types of colors. I don't think we should be stereotyping that if a boy likes pink at 5 years old, that must mean he's confused about his gender, or if a girl likes blue at 5 years old, that she must think that she is a boy or want to be a boy. This book is pushing an ideology and indoctrinating really young children with a belief system that is not in alignment with reality and not in alignment with what most parents, regardless of political affiliation, believe. And this family felt that it was in violation of their son's First Amendment rights to compel him to participate in this activity and go along with it in agreement with the message that it was sending to the younger children. And so the parents filed a lawsuit, and the court issued a temporary injunction granting the parents relief. Now, the injunction is very specific and it is a temporary injunction. So that means that this is what the court has ordered the school district to do while the case is ongoing and while they come to a final conclusion in this case. It is a huge win because the court has ordered that the school district, specifically for this buddy program, it only applies to the buddy program, but that they cannot force these students to do any of these activities without first notifying the parent that there will be gender identity issues in the lessons. So they already have to do this for health. And the defendants, which was the school district, said that it would be an administrative burden for them to provide notice to the parents in an effort for them to be able to opt out if they didn't want their children to participate. And the judge found that that was not a compelling argument, and that now they will have to give the parents an opportunity to opt out of any gender identity types of activities moving forward specific to the buddy program. Now, this case is huge because it'll have a ripple effect. So this win here on this specific program really goes to show that the child does have a First Amendment right, and that the government schools cannot compel children to go along with something that they disagree with, that is against their religious beliefs. Now, the defendants in this case, the school district, pointed to a California law that allows LGBTQ types of curriculum to be protected curriculum from historically marginalized and discriminated groups of people, which is similar to a law that was passed in Washington state that we worked hard to oppose last session. The judge ruled that this argument doesn't fly, that the anti-discrimination rules are just too broad and sweeping too widely. So what's next? The plaintiffs have to deliver a preliminary injunction text to the judge by tomorrow, May 15th. This injunction will then be in place until there is a final ruling in this case. But I would say, based on what we have here from the judge, this looks really good in favor of the parents, really good in support of protecting this student's First Amendment rights. And if this case plays out consistent with this injunction, I would say this is a huge win for parents protecting children from the indoctrination in public schools and the gender ideology that is running rampant in public schools, not just in blue states, but in red states alike. And I think what we're going to see is a bunch of cases similar to this that are going to be necessary to really start to root out the indoctrination and the gender identity and gender ideology that we have in our public school system. So this is a big win. I'm going to have a link down below in the description to the injunction for you to go check out for yourself. This is a case that I'll be following pretty closely because this is something that is really important to me as a parent and especially to us as an organization. Please share this information. I think this is a really encouraging ruling out of California that could encourage other parents to step up and take courageous action. As I mentioned, we're going to need a lot of these to dig ourselves out of the hole that we found ourselves in. If you are not already, please do subscribe to the channel and be sure to subscribe to our Substack as well, as that's the best way to get breaking alerts and calls to action. Thanks so much for watching, and I look forward to seeing you in the next video.